watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Please rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case of the day is Conahan versus State of Florida. You may proceed.
Good morning, Chief Justice Polston and members of the court. I'm William Hennis of the Capital Collateral Office
You might want to just
in Fort Lauderdale, and I'm here on behalf of the appellant in this case, Daniel Owen Conahan Jr. There are a number of issues that we've briefed in the case, but I think to begin with, I'll say a few words about the materiality of Mrs. Montgomery's testimony in relation to the claims in the case. The question, I think, in part, is whether or not the trial strategy of Mr. Sullivan and Mr. Albrand, trial counsel in the case, was prejudiced by the testimony, the surprise testimony of Mrs. Montgomery at the guilt phase in the case.
Are you, Mrs. Montgomery, as I understand your allegation, is that she has never at any point prior to trial said that her son had a friend or had met someone by the name of Daniel. Is that essentially what you're saying?
That's certainly a part of what she testified to at trial that she had never before been recorded as saying to anyone, Justice Quince.
She testified to that? I thought she testified that she thought that she had mentioned to someone. Wasn't that her testimony?
I thought the question was whether or not she had actually said that, but
that's still in dispute, I think.
She did, in her testimony at trial, say that several things. She said that she believed that she had, in her police-taped interview, given that information, and that it was in areas that were noted as unintelligible in the transcript that was provided to the defense, that, of course, in post-conviction...
Or it might have been in that area. I mean, she didn't actually say it was in that area, did she? She said it might have been in those areas that were inaudible.
I think she specifically pointed to several points in the transcript and said that she believed that that was where she had said some of the material that she indicated during her trial testimony that had never been spoken to before. And that included her warning to her son that he was going to be killed by this person who he told her had offered him the opportunity for taking nude pictures. She also, in her testimony, essentially said that this person was a madman, a crazy person who would kill her son, that it was a new friend that he had made, that's what he told her, that his name was Conahan, and beyond that he was a nurse, that he worked at the same hospital that his mom had worked at before, that he was a Navy veteran, and that he was an older person. That's all information that, for the first time, as far as the defense was concerned, came out during her trial testimony, first on cross-examination by Mr. Allbrand, and then by redirect by Mr. Lee.
Wasn't there expert testimony that reviewed the inaudible portions of the tape? It concluded that Conahan's name was not mentioned in the inaudible parts?
Justice Labarga, that's exactly right. The expert that we presented at the evidentiary hearing did a detailed analysis. He found that the unintelligible portions of the tape were only enough for a syllable or two, and that when he went back to the tape, he found a few words that he could find. And no was one of the things that he found in answer to the question as to whether or not he had any other friends or was involved in any kind of relationships with males other than the people that she had already mentioned in her police statement. She gave at least 4 different male names, including and a female name, even a counselor who had worked with her son years before at a camp. But there was no Conahan, there was no Dan.
Now,
in that police statement.
when the mother mentioned the Conahan name, there was no objection on the part of defense counsel, was there?
Well, since he was actually doing cross-examination, I don't guess he objected to his own question.
I think he said he did not say anything because he couldn't figure out at the moment how to unring that bell. Isn't that the
That's exactly what he did testify to at the evidentiary hearing. That's right.
So that's what I'd like to follow up on that. You said that the state didn't bring that out in the direct examination, this very harmful testimony that you're referring to. Is that correct?
Right.
So it came out in a series of questions that the defense lawyer asked, not knowing what was going to be elicited.
Sure. Essentially, the question was, your son never mentioned anybody named Daniel or Dan Conahan, did he?
And he felt fairly secure that since he had the tape and the prior, had he taken her deposition?
They felt secure enough that they had not bothered to depose her, which, of course, is one of the issues in the case as well, because there's reference by Mr. Lee in his testimony at the evidentiary hearing to a deposition in which he was indicating that he recalled having talked to Mrs. Montgomery prior to the deposition. Of course, there's no deposition in the record. There's no notice of deposition. The only thing that we have inferred at this point is perhaps the state deposed her prior to the grand jury testimony and has never provided that in discovery.
Now, did you raise not you, but was it raised on direct appeal that once that happened, that the trial judge should have, sua sponte, on his own, conducted a Richardson hearing? Because sometimes we see that when something has come out that no one anticipated. Did the defense counsel alert the judge at a certain point that this was surprise testimony?
I can't recall if that was specifically done on the record. What I do recall is that the trial judge in the case at the time this happened had only been on the case for a week or two before the case went to trial. Because
you're not. I mean,
well,
either
the reason I want
know.
to ask, I'm trying to answer your question, but the previous judge had actually explicitly entered an order saying that. Actually, that's not true. The new judge explicitly entered an order saying if there were any discovery issues, if there were problems about discovery, that he would, upon request, grant a Richardson hearing because he had only been on the case for a few weeks and he didn't really know anything about the case. So that was in place pre-trial.
So did the defense lawyer ask for a Richardson hearing?
No, he did not.
Is that one of your claims of
Yes,
deficiency?
it is one of our claims. It's a related claim.
Okay, so let's go take it to the prejudice point. If he had asked for it, certainly since it wasn't in the prior statement, judge would have granted a Richardson hearing. At that point, since, as you say, the bell had already been rung, would your argument be that there was really nothing to do other than to grant a mistrial?
That's certainly one response.
Well, what else
of course, you've got to remember that this was a bench trial as well, so you didn't really have a jury present.
And that is important, isn't it, as far as our evaluation of prejudice?
Sure, absolutely. I mean, this is a situation in which there's a lot of discretion that's implied on the part of the judge in a bench trial at the guilt phase, as well if it had been at the penalty phase.
Well, the
but
point
it wasn't.
did the judge know before deciding whether to find this defendant guilty that the testimony that Mrs. Montgomery offered, that the first time anybody heard it in any kind of in this devastating way, was at the trial? Was the judge aware of that?
Yes, I think so, because what Mr. Allbrand did was attempt to impeach the witness with her prior plea statement, specifically by pointing to the fact that she hadn't made any of these statements that I outlined before in her prior statement.
Well,
and, of course, that's when she pointed to the unintelligible portion.
Well, okay, so since we have a trial judge rather than a jury, what else could defense lawyer have done to show that this was pretty incredible, because this is the first time that she came up with this? You're saying it's devastating, but I forgot that this was a non-jury trial where we have a judge who has the sophistication and to realize that this is the first time it's being offered. I'm trying to sort of see then what should the defense lawyer have done, and then what should the judge have done?
Well, certainly, as soon as that first answer came out of her mouth, in addition to requesting the Richardson hearing, he could have asked for a recess and an opportunity to depose the witness based on the fact that the prior statements that he had been provided with the state didn't include any of this information.
So I assume you did that, and did you offer her at the evidentiary hearing?
No, we did not offer her at the evidentiary hearing, Your Honor.
So how do we know that even if he had done that, the defense lawyer, it would have made any difference? If you don't, it's your burden, I know you're aware of that, to establish both deficiency and prejudice. So if we don't know what the effect would have been of then deposing her, and it's clear that it's not in the inaudible portion, then isn't she sufficiently impeached by what was in fact done at the original trial?
I think not, and I think the reason goes back to the fact that this was a bench trial. I think once the cat was out of the bag in front of the judge, the reality is that there's not really very much that could have been done beyond a mistrial in that situation.
You just contradicted yourself. You just said that it was, you would have asked for if it were you would have asked for a recess so you could depose, now you're saying they should have moved for a mistrial, but is that, I didn't
Well,
think...
that was in response to your earlier question. I mean, I'm trying to...
But you would have also had to ask for a new judge, wouldn't you? I mean, this would have required not only requesting a new trial, but you would have had to ask for a new judge if you're saying the judge, by hearing that, now couldn't put that aside?
Well, I think we've also argued in our briefing that the judge relied on a number of things that were improper, that were not competent substantial evidence, and that's tied in with the prosecutorial misconduct claim, which also
brings
includes
me to
this
the question
information.
of how did the prosecutor actually use this information? Did the prosecutor, during closing argument, actually argue that you've heard that we know he met this man prior to this murder, you've heard that from his mother, that kind of information?
Absolutely. He argued in closing. He argued in the motion for a new trial at least twice. He connected her testimony with the Williams Rule testimony and the testimony by Hal Linday and a number of other things, which is outlined in the briefing, which we argue is what allowed the judge to make the finding allowing the Williams Rule evidence in, that this testimony was actually the linchpin that connected everything else. For example...
Let me ask you this,
yes.
though, before you get to the Williams Rule.
Sure.
Was there any other witness, any other kind of evidence that was presented that tied the defendant to the victim other than the mother's testimony that he had met him?
The state's brief claims that the testimony of Mr. Whitaker, who owned the trailer in which Montgomery was living around the time of the murder, and a snitch witness who talked to Mr. Conahan in the county jail after he was arrested, Mr. Newman, also provided support for that. As we said in our briefs, I think in some detail, Mr. Whitaker gave 3 or 4 pretrial statements, all of which were impeached. By the time of his trial testimony, all he was willing to testify to at that point was that Daniel Conahan at some point came around looking for Mr. Montgomery. He backed off his prior testimony that Mr. Montgomery and Mr. Conahan had gone on beer runs together, that they had spent 45 minutes at his trailer, that he had come by numerous times. And we believe, of course, that the reason for that is if, in fact, Conahan had a prior relationship that the state had to deal with, that would explain most of the physical evidence that the state used, the fiber evidence in the Capri, the fiber evidence transfers to the home, if there was a pre-existing relationship. So that by the time of trial, Whitaker's only saying, Conahan came by and looked for him one time. As for Mr. Newman, the other witness, well, Mr. Newman was, I believe, a convicted murderer, was charged with first-degree murder at the time of the trial and testified that Conahan told him that Montgomery was a mistake. That was the time.
Let me ask you this. I can understand that these 2 witnesses were impeached, but my real question is, if the jury believed their testimony, we would have other evidence that connects the defendant to the victim, wouldn't we?
Well, if we had had a jury. But we didn't.
But we have a judge who is listening to this testimony too. The judge is in the place of the jury. He's going to make the credibility determinations, correct?
And in fact, one of our IIC claims is related to the fact that there was a jailhouse witness that had been prepared by the investigator for the defense that was specifically prepared to testify relating to the credibility of Newman, again, to impeach his testimony, and yet for unknown reasons to Mr. Conahan and us, he was never presented. If I could just say one moment, I know I'm into my rebuttal time, I believe, 4:48, is that right? Yes. Just so that I can mention, I wanted to say something briefly about the penalty phase claim, which we really didn't respond to after our initial brief. All I really wanted to say was that I think that the failure by the defense team to interview Hal Lindy at all is a striking omission on their part and calls into question Mr. Sullivan's testimony about the penalty phase. Mr. Lindy was one of the
prior boyfriend?
He was the prior boyfriend who the state put on for the proposition that Mr. Conahan had a deep, dark homosexual fantasy that ended in murder and rape. And, of course, that's not what Mr. Lindy testified to. But, again, his testimony was crucial in getting the judge to bring in all the Williams Rule evidence. So I think for penalty phase purposes, you definitely should look at that in combination with the testimony from the mitigation specialists and the attorneys themselves and the documentation, because I truly think this is a case where the deficient performance was so extreme at the penalty phase that it equals prejudice. It's one of those rare cases in which that's the case. So I'll sit down now and use the rest of my time for rebuttal, if that's okay.
May it please the Court, Assistant Attorney General Charmaine Millsaps representing the state. I'd like to talk about some of the same issues, but I would like to hop straight to prejudice on the not holding a Richardson hearing. Robert Whitaker.
Yeah. Before you do that, I'm very concerned about what the state knew before they put the mother on. Is this a situation where they gave the defendant the recorded statement, but they knew about other statements and they knew about this testimony and didn't produce it for the defendant?
No. That's
no
not what
idea
happened. The state had a tape recording of the mother talking to 2 days after the crime occurred, and we had a transcript. And we gave that transcript to defense counsel. And defense counsel, we know he had it because he impeached the mother with it. Understand, there's no discovery violation here. What the state had, the state gave to him. When a witness says something completely different, it was as much, as far as the prosecutor goes, what we had, we gave to him. What the mother started testifying to was this, about, I was crying. It was 2 days after her son was murdered. And she said she was crying, and she pointed to where she thought, which defense counsel had in his hand. Understand, Richardson is discovery. We had a transcript. We gave that transcript to defense counsel.
No, I'm looking at, what I want to know is how did the state on redirect know about all these other details about this, the defendant, that he had been in the Navy, he was a nurse, and this? Was that known to both sides before the trial?
That the defendant had been in the Navy was independently known. Yes,
it was in
and
the
they
statement?
tried. There was an assault in the Navy. So
no, I'm asking you. Did they know? No, did Mrs. Montgomery not? Did they know Mrs. Montgomery was told by her son, the victim, that the person he had met, that now she's revealing as Conahan, was a nurse in the Navy? So how did, if they didn't know that?
I know. We got the defendant's records, Navy records, independent source. We didn't know that from the mother.
So understand? Then why did you cross-examine? Why did they know enough to cross-examine her about it? Well, how would they know she knew about it unless they knew that she knew about it? Am I missing
The question
something?
is really, if the prosecutor asked the mother about him being in the Navy, how did they know she knew that?
Okay, but the prosecutor didn't ask. Understand, this all happened on cross. Defense counsel asked this. And then he says statements like, in for a penny, in for a pound. Okay? So it's this, understand what we put the mother on and what happened on the direct.
Okay, let me make sure I have the part I'm concerned about. On redirect, the state proceeded to elicit additional information that her son had told her the man was older, lived in Punta Gorda Isles, was a nurse, and had been in the Navy.
That's not redirect, Your Honor. That's cross. Defense counsel's bringing that out about the Navy and the living in Punta Gorda. Okay? I'm redirect. I remember telling him, oh, you're right, Your Honor, it's redirect exam. I remember telling him his new friend lived in Punta Gorda, him telling me, and that he'd been in the Navy, and that he was a nurse who worked at the medical center.
Now, what I'm asking you, I think it's a very simple question. How, if this was all a surprise to the state, did the state know that that her son had told her all this additional information that was not in her recorded statement?
The prosecutor asked, and that's what the mother said. Now, we knew from an independent
What was
source.
the question that the prosecutor asked?
Mrs. West, this conversation that you had with your son that you were just asked about, meaning
And
by
that
defense
is
counsel.
the conversation that she had talked about in the direct.
In the cross.
And I'm sorry, in the cross.
Understand what we did in the direct. We, the state, put the mother on for one reason and one reason only, and never got near any of what we're talking about. We wanted to prove he was slight and fair-haired because that description, his physical description,
what was the question?
matched the Williams rule victim. Then on cross, everything we're talking about happened, and then on redirect, prosecutor, in the first question out of his mouth, asked, Mrs. West, this conversation that you had with your son that you were just talking about at trial testimony, where he mentioned the name Conahan, and you thought at first he said Conahan, did he give you any information about this individual, Conahan, as to where he worked or his background or anything like that? Okay? So, prosecutor, I don't think you could say that he knew all this.
Did he testify at the post-conviction hearing?
The prosecutor Lee testified.
Did he say he did not? So then did he testify under oath that he did not know this? It was just one of these things that every trial lawyer knows not to ask, which is you don't ask a question that you don't know the answer to. He said he just decided to ask these questions because now he was getting into an area that he had no idea about.
Okay, but which one are you talking about? That describes more defense counsel than...
Well, that's why the defense counsel, that's a pretty...
They called the prosecutor, we called the prosecutor at the evidentiary hearing. The prosecutor tried to explain this all in detail, and they kept cutting him off. And the prosecutor was called at the very end. They did not ask the prosecutor, what did you know when about the mother?
Okay,
and when the prosecutor tried to explain all of this, we're not asking you about that.
This is a very serious, from my point of view, this is very serious. I want to know, did the prosecutor, it's also the state's obligation to seek justice, did the prosecutor testify under oath that he did not know about these statements, these additional statements, until Mrs. Montgomery got on the stand and testified to that on cross-examination?
As I understand, Your Honor, it was not fully explored, so I'm not going to be able to fully answer your question. It was an obligation that they had if they're saying Richardson. The prosecutor...
No, I'm talking about Brady and Giglio. I'm not talking about Richardson. There's a Brady claim here that's
yes,
raised.
There's a Giglio claim.
Did the state, you're saying as an officer of this court here, that the state did not know until cross-examination that Mrs. Montgomery had this additional, somewhat devastating information about the relationship between the defendant and her son.
And I'm telling you, it wasn't fully explored. What the prosecutor did say is this at the evidentiary hearing. At a depot, not the mother's necessarily, but at a depot where he was talking to the mother, she had told him some of this at a depot.
I thought there was no deposition of the mother.
There was no deposition of the mother. But they didn't fully explore this. I'm not going to be... They have the burden on Giglio. They never asked him, did you know this? Did you?
So I guess your answer
they never
is you
proved
do
it
not
was
know
law.
as you are here today whether the state knew this before or not, and then therefore it's a failure now of Mr. Hennis for not exploring it, as opposed to the state being forthright as to whether you knew it or didn't know it.
Yes, and the prosecutor tried to be forthright, and they cut him off at the evidentiary hearing. So this Giglio claim is...
Let me ask you this. The prosecutor did not say during the course of the evidentiary hearing that there were other times that they talked with Mrs. Montgomery, and that some of this information came out during these other oral discussions with her, and that they were not asked about oral discussions. That didn't come out at the evidentiary hearing?
The prosecutor at the end, he talks about at a depot, not necessarily the mother's depot, at a depot, probably somebody else's depot is the implication. He's talking to the mother, okay? And the mother says some of this.
He's talking to the mother at someone else's depot. Well, she's present at the depot.
I think it's the daughter's depot, Your Honor. It makes more sense. But none of this is on the record, Your Honor. I mean, I think it was more likely Carla's depot, the sister, her daughter. This is the mother of the victim, but that's not on the record. I don't know whose depot it is. What the prosecutor says, and he's trying to explain all this, and they won't let him.
What did he say she told him at that depot? What was the content, the substance of it?
We didn't even get that far. He just said she talked to me at the depot, and they never explored this. I'm sorry, I cannot answer.
So that was it. He said that they talked about.
I talked to her, about her statements, and that was it. And when the prosecutor kept trying to go, the prosecutor was openly trying to explore this. And they kept cutting him off. They cut him off twice, Your Honor. So I'm not going to be able to answer your question about exactly what the prosecutor knew exactly when. But it seems from, if you read it, it was a surprise to both of them. He just says at that redirect, the prosecutor just says, okay, you were just talking about Conahan. What else do you know about this Conahan man? What else did your son tell you? That's all he said. Now, we knew about the Navy independently because they were purposely trying to keep the Navy out of there because there was an assault during the Navy. But we knew about that independently, that the defendant had been in the Navy and that there'd been an assault while he was serving in the Navy. We knew about that independently. That's not from the mother. That we knew about the Navy proves absolutely nothing about what we knew about the mother.
But the real devastating portion is the fact that she says her husband told her this was the defendant's name. And so when do we have any idea from the evidentiary hearing when the prosecutor knew that the mother knew the name of the man he had met recently?
From the evidentiary hearing, no, but let me back up. Remember, Giglio has two prongs. They have to call the mother or somehow prove that she was lying, and they did not call the mother. We haven't even proved this testimony is false. The mother said, I talked to them before the recording, okay? She's talking to them before they pushed the button. We don't know that the mother never said this. We don't know when this happened, okay? But secondly, I'd like to talk about the prejudice here. All this really proves, this is not devastating at all. All this mother's testimony proves is that the defendant knew the victim. Robert Winokur was totally unimpeached on the one statement I'm relying on. 2.5 months before this murder, the defendant, Conahan, comes over to the trailer asking for the victim, Stephen Montgomery. In other words, we have independent proof, unimpeached, that these two knew each other. That's all this proves. This is not independently devastating. We know this from another unimpeachable source.
Well, it just seems to me this whole thing is just defying common sense. That if I'm a prosecutor and I know that a witness can connect the defendant to the victim as closely as occurred here, why in the world would I not use that on direct examination and wait for a defendant to bring something out on cross? This makes no sense to me, this whole thing.
Exactly, so it doesn't make any sense that he knew. Understand what the prosecutor did and all he did on direct. We wanted a physical description of her son.
Excuse me. To suggest it's not devastating is a little beyond the pale when you connect in a case like this, a brutal case like this, and you connect the defendant to the victim.
And we have another witness.
And with all this other stuff.
And we have another witness that does that. His roommate does that too. His roommate says the defendant came over 2.5 months before this murder asking for this victim. We have another independent source, the victim's own roommate. Unimpeached. The stuff he's talking about impeached, that part's unimpeached. We have another witness, and that's who we relied on to connect them. That's how we were relying on them. We weren't relying on the mother for this. We never asked her any of this. We wanted the mother to describe him physically because he physically matched are a very important Williams rule victim. It's the Williams rule that's devastating here. It's Stanley Burden that's devastating, who describes what this court on the direct appeal said was a unique crime. We had a true signature crime, and we had the victim of the other attack, Stanley Burden, who lived. That's what's devastating here, and this mom does absolutely nothing to that. Okay? They're trying to make it, somehow attacks the Williams rule. That's not what the trial court found, that the Williams rule attack, and this court agreed with that on the direct appeal, was that the attack on Stanley Burden was not only unique, being tied to a tree, taken to a remote area, photographs taken of him. That's exactly what the state's theory happened to this victim. And the mother has nothing to do with that. This is all on cross, and all the mother does on cross is prove that these two knew each other, and we have another independent witness that does that. The devastating evidence here is the Williams rule victim.
Was there a jailhouse snitch here?
Yeah, his name's Newman.
What did he say about the defendant's knowledge of the victim?
They shared a cellmate for a few months. And Newman said that at first Conahan said he didn't know the victim, and then he admitted that he did, and he said Montgomery was a mistake.
And was that portion impeached or not used or what?
No, it was used, and Newman was presented, and it was impeached in the sense that he was a convicted felon. Newman was a convicted felon. But I'm not even relying on that. I'm relying on a roommate who was not impeached regarding 2 months before this crime that they knew each other. Conahan came over to the trailer that either at the time or right around that they shared, and asked for Stephen Montgomery, the victim in this case. The devastating evidence here is not even that they know each other.
I was under the impression that the mother of the victim did more than just identify a name. Am I incorrect in that?
Okay. No, Your Honor,
she testified as to almost the modus operandi that's involved here, didn't she? Did she talk about photos and money?
She did talk about photos and money.
She sort of painted the picture of the crime.
He told me that someone had offered him $200 to pose for nude pictures. He didn't tell me who. He refused to tell me who. I told him to stay away from that person, that he would sexually abuse him or even kill him. At that point, the defendant screams, "You're a liar." But yes, but he didn't. She did not say who it was. And I think the statement
just beyond me. This defies common sense that she would have not told law enforcement her son has been killed. They find his body, and that this is not something that would have been discussed with law enforcement. This whole thing is like a fairy tale.
Okay, but Your Honor, if you're going, you need to call the mother at the evidentiary hearing. You need to let the prosecutor explain what he knew when. If you're going to prove a Giglio claim, you need to prove a Giglio claim.
I mean, you may be right that's where all the holes in this case are.
Yes.
Is the failure during the post-conviction to fully develop all of what happened. I mean, because I'm sorry. You don't lose common sense once you go into a courtroom. And this whole thing is just,
I agree with that.
It's not fitting together.
I agree with that, Your Honor. And what needed to happen was not only did the mother need to be called, but the two agents that she talked to this tape, an FDLE agent and a Deputy Smith, they should have been called about what did the mother tell you when. Okay, and then the prosecutor should have been allowed to explain what he knew when. And they had the burden here. They have neither proven that the mother's testimony was false, nor have they proven that the prosecutor knew it. Okay, and you have to do both. And then I don't think there's any prejudice anyway, because what this mother's testimony on cross, the state didn't even ask her any of these questions that we're now litigating and arguing on appeal. We asked her, what does your son look like? And the whole point of that was that he was slight and fair-haired, which is exactly and what the trial court relied on, which is exactly the physical appearance of our Williams Rule victim, Stanley Burden. And that was, so we did what we wanted to with the mother, and then this all came out on cross.
And redirect.
And then redirect. Yeah. And the prosecutor starts out with, okay, you said he knew Conahan. I take that to be, tell us some more. Did your son give you any more information about this individual as to where he worked or his background? That's what the prosecutor asked. And then the mother says he lived in Puerto Gordo, he'd been in the Navy, he was a nurse who worked at the medical center. The mother says that. And then she says
in what she testified to, was there a connection between the offer of money and Conahan?
And
those are two separate things.
They are two separate things, and let me give you the exact line I'm doing that. This is the mother. He did not tell me who, referencing her statement about the offer of $200. He refused to tell me who. So she did not connect the offer to Conahan. That is a disclaimer. I don't know who made that offer to my son. Okay? But what I'm telling you is that this needed to be explored more fully. If they're going to claim this is a Giglio violation, Mom should have been.
You keep on saying, but there's two. There's Giglio and Brady, and so you agree they've raised both of those claims.
Well,
one has to do, as you know, with presenting false testimony. The other has to do with having known something before and not revealing it. And what you're telling me, as opposed to the prosecutor didn't know, you're saying that Mr. Conahan has not established it. And I accept that that's the case. It's just troubling that we're here on of course, the most serious of cases, a death penalty cases, and we don't know what the prosecution knew when. And and you cannot say as an officer of the court that the prosecutor did not know that, which is why it seems that if there was a Richardson hearing, it would have been developed. We would have known it. And that's one of their claims of ineffective assistance, that we should have had a Richardson hearing. The defense lawyer, if he was surprised, which he was, should have asked for a Richardson hearing, and we would have known straight from the prosecutor at the time what was known and not known. Correct? That's what Richardson's about.
Well, no.
No, it's not?
Well, Richardson about discovery. You have to give me what you had. What we had here was the transcript. You're not going to get very far with the Richardson hearing. The judge is going to say it's in your hand. The transcript's in your hand. You were truly given that. So, but Your Honor, let's go through it as Brady.
I think you're out of time.
I'd like to hear her comments about Brady. Go ahead.
Brady has 3 prongs. This is not exculpatory because it ties the defendant to the victim. If you're going to do it, you're going to impeach the mother, but you're not going to impeach her for what the state wants. The state wanted her to prove the physical characteristics of her son.
Well, did the Brady claim in this case have to do with the mother's testimony or something entirely different?
They raised the mother's testimony as a Giglio claim. The Brady claim here is the undercover recording. I took this mother's testimony to be a straight Giglio claim, not a Brady claim. It's the undercover cops that's the Brady claim. So I think this is a straight Giglio. Giglio has 2 parts. You prove the mother lied, and you prove the prosecutor knew they lied. They did neither of those because they didn't call the mother, and they wouldn't even let the prosecutor talk about this in any detail. Every time he tried, they cut him off. They have not proved a Giglio claim. Your Honor, I think you think I'm not. Of course a Giglio claim would be horrible if they proved it. My point is that they didn't prove it. I'm not trying to say Giglio isn't a bad thing for the state to do. Of course the state shouldn't lie. But understand, we didn't put this mother up there for any of this. None of this was what our purpose was for the mother. Okay. And we didn't ask her any of this on direct. This was all cross. Thank you very much.
I could have just a little leeway beyond my time, Your Honor, since...
You have 3 minutes, 27...
Materiality, I just want to go back to where I began. The only witness in this entire trial who testified that somebody offered Mr. Montgomery $200 for nude pictures was Mrs. Montgomery. And it was in the same answer to the State's questions about Mr. Conahan. So there's an inexorable link.
But is it accurate that she specifically said that he wouldn't tell her who it was?
Absolutely, she said that. Absolutely. I also want to point out, as to the question about the officers testifying, we called Agent Ciccone at the evidentiary hearing, one of the people who interviewed Mrs. Montgomery on April 18th, 1996, which incidentally was long after the murder. The conversation that she referred to took place on March 23rd, 1996, according to her. And the eventual identification of Mr. Conahan as a suspect was over a month later, and it was related to what they call in the case report the Belle Glade incident, which has to do with a completely different witness. But as to Mr. Lee's testimony, the record will speak for itself. Go look at it. Mr. Lee specifically says that he knew the information that Mrs. Montgomery testified about at trial prior to her testimony.
Who was he?
And he says it was at the deposition.
Who is Mr. Lee?
Mr. Lee is the assistant state attorney who was both the trial state attorney and who also has been on the case during the entire course of post-conviction.
Well, you don't raise a Brady claim. Assuming it's true, then wouldn't that have been a Brady claim that you should have raised?
Perhaps so, Your Honor. Perhaps so.
If she's truthful about it, then that's not Giglio.
If she's truthful about it.
If what she said is in fact true, Giglio prevents the state from putting on false testimony. Brady, I'm sure you know this better than I do, requires the state to turn over something that is exculpatory.
And the basis for our Giglio claim, of course, is the transcript in which she says none of what she said later. Now, as far as what she specifically told,
she told the police, so that would seem to show that it was truthful. It just wasn't revealed to the defense, apparently.
Maybe I should get back to it. We called Agent Ciccone, and Agent Ciccone testified. He was present at the taping of the conversation. He testified anything that she would have said during the interview, during the pre-interview, any of the time he spent with her, he would have put in his notes. He reviewed his notes. He had them at the evidentiary hearing. He said if there had been a name, Dan Conahan, or anybody else other than the names that were in the transcript, they would have been in his notes, and he would have done a report about it. So we did exactly that.
I'm getting a little confused here because you're talking about two different police officers. One who says that he would have put all of this in his notes if she had told him.
Right.
Yet you now saying another police officer that in fact say that she said that.
Well, I'm saying that Mr. Lee, who was the prosecutor, testified at the evidentiary hearing that he knew the information that she testified to at trial. And the reason that he didn't reveal that to the defense was that he had no obligation to, because it wasn't written down. That's what he testified to. And in fact, he was on the case from the first day we filed a state post-conviction motion.
So is that a Brady claim? If the fact that he knew and didn't turn it over to the defense because it wasn't in any written form, is that a Brady violation?
If he's a state agent as the prosecutor, then it's a Brady violation.
So why wasn't that raised as a Brady violation as opposed to, it seems to me the only Brady violation that's in this case has to do with a recording by an undercover police officer on May 29th. Is that correct?
That's the missing tape recording, yes.
But that has nothing to do with this issue of when and where Mrs. Montgomery told the state about the defendant, correct?
No, there's no direct relationship
other
than regarding the Williams rule evidence.
All I'm asking you is there or is there not a Brady violation based on the fact that the prosecutor had information that was not turned over to the defense? Well, concerning Mrs. Montgomery.
It appears, based on the state attorney's testimony at the evidentiary hearing, which was less than a year ago, that there may well be a Brady violation based on his testimony then.
But that we don't have that before us.
You apparently don't have that before you if it's not in the pleadings.
So let's go to Richardson. What you would say, we'll go back to what you originally said. If this was a surprise, a devastating surprise for the defense lawyer. And obviously, from my point of view, the prosecutor must have known about it because, I don't know, well, it just seems he said he did.
I think the record was...
So let's say that it was deficient conduct, and the judge didn't know it was new because no one told him it was new, and it was a new judge. So let's assume it was deficient conduct not to have requested a Richardson hearing. Then you still have to prove prejudice from not having requested a Richardson hearing. And what we're looking at then, you said, well, maybe he could have taken a recess and questioned Mrs. Montgomery more. But really, there doesn't seem to be then what you have is probably deficient conduct in not bringing this to the judge's attention so that they could have found out what was going on. But where is the prejudice that is undermining confidence if, in fact, what Mrs. Montgomery has to say is true, which is apparently what it must be based, or it's not, we can't say it's false, so let's assume that it's true.
I think the prejudice is in the judge's ultimate reliance on that testimony in his findings, both the oral findings regarding the Williams Rule and the written findings that he did subsequently involving the Williams Rule, in which her testimony was the linchpin for those findings. Well,
the finding would only be about him being fair-haired, and I thought that was. But anyway, you're way beyond. I think this is a.
I think if you look at his order on Williams Rule evidence, which is 16th of August, 1999, and consider that in the context of the question you just asked me about prejudice, and think about that in the context of Mr. Conahan being portrayed as a serial murderer when he wasn't even convicted of sexual battery in this case, based on the evidence, where the medical examiner, Dr. Amani, said that there wasn't any evidence of sexual battery to the victim, and yet the State's said the opposite all the way through the case. And to get back to Mr. Lee, the prosecutor, just remember that the State, in its responses to our post-conviction motions all the way through this case, had the opportunity to provide in response to our claims, Brady and Giglio, regarding Mrs. Montgomery's statements, the opportunity to come forward with what Mr. Lee, who was also the post-conviction prosecutor, knew. It's only when we call him at the evidentiary hearing for purposes of clarifying this that he comes up with this testimony that he's the source, not, as they've been saying through all the pleadings, that it's unidentified police officers.
If you could sum up.
To sum up, I think that the Williams Rule stuff in this case is really the story of the case. It really was a mini-trial. It really was a situation like Durousseau, in which the judge never found clear and convincing evidence of the Williams Rule. Look at his oral order, look at his written order, and the whole idea was that the State portrayed him as a serial killer that they just didn't quite have enough evidence for. They didn't have any DNA evidence except DNA evidence that exculpated Mr. Conahan, so there was no DNA evidence put on this case. So the State relied on the Williams Rule. They relied on false evidence. They relied on witnesses that recanted up until the time of trial, so that they're only doing identifications, like hundreds of people in the county area who knew Mr. Conahan could have come in and testified, oh, yeah, I knew him. And they're relying on Whitaker's testimony essentially to support the fact that Conahan had some contact with Mr. Montgomery, and yet backing off from what that might mean for their fiber evidence and for their paint chip evidence. And that's why they presented the evidence the way they did. Thank you for that additional time. I appreciate it, Your Honor.
Thank you. The next case we'll call is Franks versus Bowers. Counsel for petitioner, ready to begin?
May it please the court. I'm Tom Edwards of Edwards and Raggots, and I'm here representing the Franks family. This case comes to you as an arbitration case where both parties agree that de novo review is appropriate. In the week that you issued the jurisdictional order in this case, you also issued the Gessa and Schatz opinions that we believe control this case. Let me briefly explain to you how we got here and talk to you about the arbitration agreement at issue. Mr. Franks went to the North Florida surgeons for care and treatment after finding a lump in his groin. He didn't know whether it was cancer, whether it was a hernia that could incarcerate and kill him. When he sought his medical care, and let me preface this, we asked for an evidentiary hearing. It was denied, so there's no evidence as to what took place when these documents were executed.
I'm not sure I understand. You asked for an evidentiary hearing in the trial court?
Yes, ma'am.
And the evidentiary hearing was denied for what reason?
There's no reason given. It was simply denied.
Did you raise that as a separate issue on appeal to the First District?
It's been raised throughout.
That's error. I mean, we don't know whether he knew what he was signing or didn't know anything about that he knew he was giving up rights that he'd have under the medical malpractice statute.
Yes, ma'am, and that is
Did you not know?
That is the second issue that we are presenting. The first issue is we don't even need an evidentiary hearing because for public policy reasons, this arbitration agreement is invalid.
What issue is that in front of us? The issue that there is that the trial court erred in not granting an evidentiary hearing on the circumstances of signing the arbitration agreement?
We raised that in the brief and in the relief. We saw it in the brief. In the conclusion, we specifically asked for it to be remanded to address those issues.
But what issue is it a part of? It's not delineated as a separate issue, so is it a part of one of the other? Is it a part of the public policy issue or the unconscionable issue? What?
Yes, ma'am. We addressed the way in which this got executed as a part of both of those issues.
What page is that in your brief?
Judge, Justice, I will find the page in the brief and address it when I get back up. At the time this agreement was executed, the second and let me say this: the agreement is a 4-page agreement. The best copy you will find of this agreement is in the defendant's appendix, the appellee's appendix. And the copies we had are multi-generational copies. It's a 4-page agreement. In the middle 2 pages deal with arbitration. There's a caption that says arbitration. The second paragraph essentially tells this patient, if you're not going to sign this agreement, you can go find other doctors.
But the title of it is North Florida Surgeons Financial Agreement?
Yes, ma'am. And then on the second page, there's a subcaption right here that says arbitration. That same caption is here on the 3rd page. You're probably not going to be able to read it in the one you've got there.
It's in a darker portion?
Yes, ma'am.
Oh, okay. Yeah.
It's right here. The second paragraph tells the patient that there are other physicians they can go see if they're not agreeable to this. It then discusses only Florida law. It does not adopt the federal law. It indicates that the patient must comply with Chapter 766. It does not indicate an obligation of the doctor to participate or comply with the pre-suit process. It indicates that the patient must. It then goes on to talk about the right to jury trial and then addresses the limitation of damages and states that the patient is going to get damages under Florida Statute 766.207.
If you could just, on that particular issue, as I understand it, on Chapter 766, which is the malpractice statute, there is a provision for arbitration if one party or the other requests it. If the doctor agrees to arbitration, and then the doctor has to admit liability.
Correct.
And there is a limit on non-economic damages of what?
The $250,000 limit, which is the same limit they address in this agreement.
I mean, so the only difference, or is there another difference between what is agreed to here and what is under Chapter 766? Is that they didn't admit liability?
They did not admit liability here. That's correct.
The only difference?
That is not the only difference. There are multiple other differences.
Well, give me the highlights.
The highlights include the fact that they have to agree to be joint and severally liable. So if you go to the med-mal arbitration, you're not at risk for having inconsistent results with other defendants. And in this case, there were other defendants. So this agreement does not subject them to joint and several liability, whereas the medical malpractice statute they cite in here would have. It provides for sanctions if they don't pay the judgment quickly, including an 18% interest rate if they go up on appeal. It provides for an expedited process. It provides for a number of other things that are actually outlined in a great deal of detail in the St. Mary's and in the Acharte case. One place you can find the other issues is at page 970 of the St. Mary's case, where it lays out the 5 things the court views as the benefits to the plaintiff, virtually all of which were taken away by this agreement. And the plaintiff was not told that. There's no way a plaintiff, a layperson, could ever understand when they're being told you're getting these statutory damages. There's no way they could understand that there's this complex scheme with all these...
Well, they're not getting any... I mean, basically, they're not getting anything.
Correct.
But they're getting less than what the Florida legislature deemed to be appropriate for a victim of medical malpractice.
And they are not... they're not
What are
told,
they getting in exchange?
They're not told that in any way, shape, or form. This agreement did exactly what is discussed in GESA. It ends up gutting what Acharte and St. Mary's said were the benefits a plaintiff is supposed to get that form the quid pro quo in this entire Medical Malpractice Act that serve as a basis for caps to be imposed.
Well, is there a difference, though, between the nursing home statute that is actually giving patients more rights than they would have at common law and the medical malpractice statute, which is giving plaintiffs less rights than they would have at common law? In other words, the legislature has already lowered the rights. Is there then a where's the public policy argument to say, well, doctors, because the legislature intended to lessen the rights, that doctors can continue by contract to lessen them even more and it not be void against public policy?
Because this is a remedial statute, it creates remedies.
But is that what we mean? See, because I always use remedial and statutory construction. Remedial statutes seem to be ones that usually benefit a plaintiff or somebody. This medical malpractice statute is not remedial. It doesn't help the injured person. It's remedial for doctors.
In one area of the law, it takes away rights, but in another area of the law, it grants additional rights. And this court says that in both the Acharte and St. Mary's. And if it did not grant additional rights that were considered a quid pro quo, rights that the plaintiff would not otherwise have, there would be no constitutional basis for this entire statutory scheme. And that's what both Acharte and St. Mary's say.
If there was no medical malpractice statute, say this, it doesn't. There are certain areas that the medical malpractice statute doesn't apply. Forgive me if I don't remember. Are dentists covered? There is some. Give me somebody that's not covered.
Candidly, this is such a complex area. I have to always go back and look.
Okay.
But for example, a pharmacist is not covered.
Okay, so let's assume that the pharmacist, you go in to get your drugs, and the pharmacist has you, as part of the financial agreement, sign one of these. Can under the law as we have it, can a potential tortfeasor basically allow or limit rights if the legislature has not yet legislated in that area? In other words, if it's just a standard tort claim, is it different than when there's a statute?
I believe that under the Moranis case, they would not be allowed to. And the Moranis case is a case that talks about professionals in the context of the economic loss rule. But the Moranis case, which is cited in our brief, discusses the fact that contracts should not control tort rights as between professionals and lay people. And that is consistent with the holdings of many other states because they are providing necessary services. And in the Schatz case, in the slip opinion, I believe starting at page 19 through 23, this court adopted language from the Steele opinion written by Judge Altenburn. And it talks about how a layperson in a healthcare setting has no ability to negotiate these contracts. They can't do it. They're in too weak a position.
So if for example, this patient had struck through any of these provisions, could the patient do that?
There's no evidence.
Assuming that we would, and we should, read these kinds of things that are put in front of us, and if I had decided that I didn't particularly like the patient understands about constitutional rights, or I didn't like the provision that talks about this being arbitrated, could I strike through that provision?
There's no evidence on that issue as to how that would have been dealt with, but what the second paragraph says is you're not required to use this practice and you can go select another physician.
So doesn't that, in terms of unconscionability, doesn't that change the analysis for unconscionability? In other words, if this isn't an emergency situation, and assuming that it's not against public policy, which is a separate issue, but on unconscionability, which you've raised, if there were other doctors in the Jacksonville area and this wasn't an emergency, like going to the emergency room or going to somebody when you're about to have a heart attack, how can you say it is unconscionable if they're telling them they can go someplace else?
That is a part of what needed to be dealt with and was not. The whole issue
that needed to be developed at the evidentiary hearing that you requested.
Yes, ma'am.
If you could also, when you find that aspect in your initial brief, if you could find where you raised unconscionability, I would appreciate that too.
Yes, sir. The public policy issues that are raised go to both the St. Mary's case and the Acharte case. And when you look at the St. Mary's case, they analyze this exact statutory scheme that we're dealing with. They actually analyze 766.207, which is cited in this arbitration agreement. And at page 970 of the St. Mary's case, here's what this court said about this statutory scheme. On the other hand, the most significant incentive for defendants to concede liability and submit the issue of damages to arbitration is the $250,000 cap on non-economic damages. The cap that they took for themselves without giving any of the other rights back to the plaintiff, the rights that are set out in what is termed by this court a complex legislative scheme, in which this court also says in the Acharte case is both unambiguous and unclear. So you've got a layperson trying to figure out what their rights are.
Under the statute, 766, you have the cap on damages if you agree that you're liable.
Yes, ma'am.
That's what the statutory scheme. But in this agreement, you don't have to agree that you're liable, but you still have the same cap that the statute gives you.
Yes, ma'am.
That's your argument.
Nowhere in this agreement does it explain to the plaintiff they're giving up those rights. That's not explained. And so...
Well, but it is explained that you have it doesn't really say anything other than you have to do the pre-suit requirements of 766.
Correct. And we did the pre-suit. And we offered, under this sanctions process, We offered under the medical malpractice pre-suit process to arbitrate under 766.207, and they refused. They declined to do that. And under that process...
Well, because they wouldn't have to admit liability.
Right. Under that process, they'd be required to admit liability, agree they're jointly and severally liable for all the damages, and agree to certain other processes that benefit the plaintiff. And so they refused to do that. And let me tell you what the very first sanction is that they're supposed to be subject to for refusing to do that. And let me remind you, in the Acharte decision, this court said this is an integrated plan, and the entire plan has to work together to achieve the purpose of this set of statutes. So you can't take pieces of it, and you specifically say that in Acharte. The very first sanction that we have a right to, if they refuse to arbitrate under this process which we offered to do, Section A, the claims shall proceed to trial. So we've also...
But the question, I guess, comes down to, but a person can, in fact, contract away those rights. But can't they? I mean, can't you contract away that?
What this court has done in most other settings is significantly limit that when fiduciaries are involved and in situations like where healthcare providers are involved. You've addressed those standards in the Schatz opinion. You've addressed those standards in the Moranis opinion. You've addressed those standards in other settings. For lawyers, we have to go through extraordinary disclosures. You talk about that in one of the dissenting opinions in either Gesser or Schatz. And we then have to have a judge review it. For a trustee, the common law set up a standard where a trustee would have to go have a judge review it. So the common law has always recognized that when you've got a layperson dealing with a professional, particularly fiduciaries, and they're not on an equal footing, they shouldn't be permitted to waive rights unless there's a safeguard process in place. And the common law has always recognized that in relation to professionals.
You're into your rebuttal.
Yes, sir. Thank you.
Good morning. Kelly Mathis on behalf of Mathis and Murphy, representing Dr. Bowers, Dr. Paperno, and North Florida surgeons. Let me address first the concern about the evidentiary hearing, because the trial judge did make a finding why no evidentiary hearing was necessary. That finding was that the claim was raised that this agreement was unconscionable. Unconscionability under Florida law requires proof of two things: procedural unconscionability and substantive unconscionability. The court found, as a matter of his determination, that this agreement was not substantively unconscionable. So therefore, whether it was procedurally unconscionable really didn't change the outcome.
At least some argument about substantive unconscionability? I mean, we've heard argument here today about how, this really certain provisions are gutting what is provided for in 766. So what kind of argument was made that the trial judge based his finding on?
Well, the same arguments that were made here, that this is an agreement that no person would agree to. The standards for substantive unconscionability under Florida law are very high. It is a very high hurdle. They simply couldn't, in the trial judge's opinion, come close to meeting that hurdle. That was an issue also raised in the First District Court of Appeal below. They also affirmed no substantive unconscionability.
So what you're saying with substantive unconscionability as opposed to procedural is that we can make, in this kind of situation, we can look at the agreement and make, like, for example, if this had awarded, said that the economic damages were limited to $50,000 and the non-economic damages limited to $5,000. I mean, would there be a point at which it could become unconscionable, or in your view, that is up to the doctors or hospitals to limit rights to any level? It would never be substantively unconscionable.
Absolutely, there is a point where it would become substantively unconscionability. Our position is it's not there in this case.
On the unconscionability.
On the substantive unconscionability.
My concern, or I guess my question is, in the First District opinion, it says that the arbitration clause, as applied in this instance, affords meaningful relief and is consistent with the legislative purpose and public policy which led to the enactment. Now, I guess what I'm having trouble with is it seems like it is absolutely and completely altering one of the pole stars of the medical malpractice statute, which is the agreement to arbitrate if the parties agree that there's admit liability, et cetera, et cetera. So I'm having trouble understanding how something that eviscerates essentially that part and is at odds can be considered meaningful. So and I don't know where that standard comes from. So if you can help, because I'm assuming that that's your point, is that this agreement is pretty good compared to something else that might only allow for $10,000 in damages. So, but I don't know, where does the meaningful relief come from when the agreement is at odds with the very essence of the medical malpractice statute?
Your Honor, because there is a variance, and we see it as a slight variance of the terms, we simply don't have to admit liability is the main difference.
But isn't what we all, those of us that used to do some of this work, know that medical malpractice cases are some of the most costly, most difficult. The hardest thing and the most hardest fought issue that requires the cost to go skyrocket is liability. That's where you need your experts. That's where I mean, the damages usually would be the simple part. So how do you see that as slight? I mean, that's the huge part, admitting liability. That's why you get to arbitrate under the Chapter 766. So I just don't jump over that. Isn't that the big deal, admitting liability, not slight?
It is in those cases where there is not a question of liability, but in the vast majority of cases, the issue of liability is. But, Your Honor, that goes to the heart of what the Medical Malpractice Act is all about. And that's what we're talking about here. This case involves the issue of whether to enforce a private contract between two people. The court can void that if it is contrary to public policy. The public policy in this case was established very clearly by the Medical Malpractice Act. Very clearly that arbitration, we like it, we want it, and we need it here. We need it in medical malpractice cases. This contract provides for that arbitration.
But didn't the legislature come up with a very nuanced prescription as to how arbitration would be done in the medical malpractice field as opposed to other fields? And wasn't it sort of integrated and tiered and et cetera? I mean, how is it that that's not against public policy to eviscerate everything that the legislature set out as public policy? To not allow, I mean, if you're not going to admit liability, then that's going to eat up the $250,000 anyway, even if you prevail in terms of the cost. The attorney fees, I mean, they set out the scheme. How is it that you can just cherry pick certain areas that only benefits one side as opposed to the other, when this was clearly a balancing act that the legislature went through when they promulgated this medical malpractice statute to handle arbitration for medical malpractice in order to get the caps? If you don't go by these statutes, then you don't get the caps.
Your Honor, the Medical Malpractice Act provided for a very, very narrow of cases of arbitration. But if you look at the public policy that the legislature established, it said we want arbitration.
What are these narrow? Are you saying this case does not fall into that narrow?
Your Honor, the only narrow arbitration provided is when the doctors admit liability. And I would submit that that is a very, very small percentage of cases.
That, but the problem is, if the doctor is not going to admit liability, then how can then he's not going under the medical malpractice statute, which allows for the caps.
That is true, Your Honor. The question, though, is in enforcing a private contract, is it contrary to public policy?
Precisely.
And it's not contrary to public policy merely because it does not follow the Medical Malpractice Act directly. The question is whether the legislature believed that arbitration was in accordance with public policy and whether caps on non-economic damages were something that was necessary for public policy. And very clearly, in the intent language, 766.201, the legislature said we want and need both of those remedies to apply to medical malpractice cases, because what we want to do is we want to take these cases and we want to incentivize arbitration. We want people to go to arbitration.
And how does this incentivize arbitration on behalf of Mr. Frank? I mean, everything that the statute gave him, this agreement took away.
No, absolutely not, Your Honor. It gave him arbitration, which the legislature wanted. Arbitration in and of itself is a significant benefit. As Justice Periente pointed out, medical malpractice cases are very, very expensive cases to try, and they are very long to try. The average case takes over 3 years to get to trial.
I've handled medical malpractice cases.
All right.
Presided over them. And that's exactly at the heart of it. That's the quid pro quo. We're capping your damages because you don't have to prove up the negligence. And, I mean, that's the heart of the case. Once you get there, I mean, it's paid by the door. But if you have to prove that, I mean, and you went to the bottom rung of the caps. I mean, it's tiered, it's really nuanced. And this thing just strikes me.
The question, Your Honor, is whether parties can privately contract for this. And they can. It's a different analysis than the Acharte analysis. This is not a Kluger test where you measure a quid pro quo of everything they give, everything you take away. That test and the Acharte test applies to analyzing legislative statutes to determine their constitutionality. The standard for private contracts is much different than that.
So you can contract to have all of the burdens of 766. And then, but you get none of the benefit of 766. I mean, that's essentially what they've got to comply with all the pre-suit requirements of 766, but you get none of the benefit of 766. That's in essence what you've contracted for here.
That's not true. One of the benefits that they get is arbitration itself. As I was saying, these medical malpractice cases...
Arbitration, one of the benefits that's under the statute is arbitration after you admitted liability.
But the patient has no right for the doctor to admit liability. They're trying to establish that as a right, which they simply don't have the right for the doctors to admit liability. What the legislature recognized as public policy, which is the standard for enforcing private contracts, what they recognize is public policy is arbitration. Why? Because arbitration in and of itself leads to the prompt resolution of claims and decreases the amount of those claims. Arbitration is a much faster and much cheaper procedure for parties to go through. That
even
benefits
in this arbitration, the defendant, the plaintiff, would still have to go through all of the expenses of proving liability, correct?
They have to go through those expenses, but those expenses in an arbitration proceeding are less. And that is the point, and that's what the legislature recognized.
I guess I keep on, and I appreciate this, or I think this is very, maybe it's a nuanced case, and I appreciate the advocacy on both sides. But my concern is that we have the workers' compensation statute, which wholesale took away workers' right to sue in court, except in very narrow circumstances. But in exchange, they don't have to prove liability. It looked like that what this legislature did is say, we want to encourage arbitration, but only in situations where the doctor will admit liability. That if they had wanted to say, we're going to take the whole medical malpractice scheme and put it into arbitration, I think that this court would have looked at Acharte in a very different light. Would you agree with that, that if the legislature had done this? which is say you every claim, malpractice claim will no longer be in the court system, but will be arbitrated. Same, everything else same, pre-suit, but and limit damages. That there might have been a constitutional issue with that statute?
Well, it's a different test and a different analysis, a different case, and I understand that.
And here's the thing. This I haven't. I guess we all sign lots of agreements that when we're going in to see a doctor, and this issue really affects millions of Floridians that go to see doctors all the time and are signing. I don't know, Mr. Franks wasn't that old. He was in his 60s. It's pretty young.
That changes as we get older.
Yes, exactly. And yet, we've got 90-year-old people we've got that are signing something where they think they're signing a financial agreement. And now what we're saying is really that the doctors and hospitals are free to limit rights granted in a restricted way by the legislature, but the doctors in hospitals and emergency rooms are free to lower those rights even further, and that's in accordance with the public policy of the state. That's where I'm having a hard time. And today it's $250. Tomorrow it might be $200. How far does it go down till it's really eviscerated that person's rights?
And there is a protection for that in the unconscionability analysis that the court would still have to undertake. You pointed out earlier, what if somebody comes into the emergency room with a situation? Absolutely a different case. What if somebody can't read? Absolutely a different case. You have protections for that. But this issue is the enforcement of a private contract between two people, and what the court should do in a public policy analysis is not to microscopically dissect every provision of that contract and say, is it absolutely fair? This court has never done that in the history of contractual jurisprudence. What the court does when you're analyzing a contract is it fraud? Is it duress?
I thought what
is
we
it
do, but it's one thing to analyze a contract, but a contract that purports to take away tort rights isn't different than another kind of a contract. We're talking about really prospectively limiting rights that are granted under the common law to when someone is negligent and injures or kills a patient, that there are rights to be able to get recovery. So this is a different kind of contract, isn't it? Most contracts.
The public policy concerns are greater. I absolutely agree with that in that kind of context. But the analysis of the public policy is the same. Does it further the purpose of the statute, or conversely, does it eviscerate the purpose of the statute? And in that context, this Medical Malpractice Act is very, very different than the nursing home cases, the Schatz and Jessa case. That case, the legislature determined as a matter of public policy that we need to give these rights to accomplish these. They created new rights that didn't exist before. In this situation, and so therefore any attempt to cap what the legislature says we need is a different situation. In the medical malpractice cases, what they said is we need arbitration, we need caps on damages. To get into an analysis of is it 250, 275, 285, that's really dissecting, not under the guise of public policy. Public policy is, does it meet, is it consistent with the goals of the medical malpractice action? In this case, it is. And I'm running out of time.
Are you agreeing then that if we should determine that it is not, then this document fails?
If it is contrary to public policy.
No, the statute. That's what you're talking about, the statute. If we have a statutory scheme and that we should determine that this agreement, whatever word you want to use, eviscerates or undermines or destroys or is in contravention of, whatever word, if we should determine that, does that mean that this agreement fails?
The standard is important. If you determine that it eviscerates the purpose of the medical malpractice action, it does, but for the Federal Arbitration Act, which I was getting ready to get to.
So you got a different argument on it. Would this then, law firms, accounting firms, can now, under this theory, the state has the policy, the federal government has the policy, arbitration's a good thing. Arbitration good, trial bad. Is that where we're headed? Are lawyers, other professionals in the same category?
I think other professionals would have the right to privately contract for arbitration unless there is some specific public policy that indicates otherwise. Here, for what we're talking about in this case, though, is just doctors, not expansive to. And in doctors.
No, I think it's broader than that. I mean, we're talking about professionals, professional contract for rendering services, and this limitation. So that's my direct question. I want to know whether this ruling will, for professionals, whether lawyers, accountants, are also would be in the same category.
I don't think it has to be, because in this case we have direct intent clearly stated by the legislature that for these kinds of claims we want arbitration. You don't have that for other professionals, so I think then it's distinguishable. But let me address the Federal Arbitration Act because I'm running out of time. Federal Arbitration Act controls this case and prevents the determination that arbitration clauses per se are against public policy.
Well, it really doesn't, because specifically in the arbitration agreement, it references the Florida Arbitration Code. So the parties really have specifically chosen Florida's arbitration code to apply here.
Florida Arbitration Code provides the procedure, which the Volt case, the U.S. Supreme Court said, can provide the procedure. By referencing the Florida Arbitration Code, it doesn't mean that federal law still doesn't preempt provisions that are in conflict with that code.
How is the doctor-patient relationship in Jacksonville, how does that affect interstate commerce? How does the Federal Arbitration Act, if the health care crisis around the country was not commerce, how would the federal government be able to come into a doctor-patient relationship and preempt what they've agreed to, or what the state of Florida has said is the policy for medical malpractice actions?
The interstate commerce cases have interpreted that very broadly as to whether or not there is any involvement, and that's the standard in interstate commerce, and they have repeatedly found that in medical-type practices, that because there are patients or maybe patients from out of state. Here in Jacksonville, we certainly get patients from Georgia, where there are supplies and materials that are bought out of state. And in fact, the Marmot case decided by the U.S. Supreme Court just this year determined that in nursing home cases that the West Virginia Supreme Court could not say that because those cases are different, because they are professionals, because they provide a service that is important to the public, we are not going to allow arbitration of those cases.
Now, tell me exactly the conflict between the Federal Arbitration Code and the application of the Florida Arbitration Code here. Where's that conflict?
Well, there is no conflict, but there is a conflict if this court were to hold either as a matter of public policy that this arbitration agreement would not be enforced.
And what case of the United States Supreme Court is going to hold that?
The Marmot case, Your Honor. Marmot, M-A-R-M-E-T. We provided a notice of supplemental authority a few weeks ago. It was decided, I think it was February of this year. But the Marmot case is directly on point. It involved 3 nursing home cases. The West Virginia Supreme Court said as a matter of public policy that you cannot provide for pre-dispute arbitration of nursing home cases.
So it may be that the shots and guess, are those up before the U.S. Supreme Court now?
I don't believe that they are, but there is some question as to whether or not those rulings are still valid in light of that Marmot decision.
Okay.
But
if you could just sum up.
I will sum up. So what we have here is a contract that accomplishes the two explicit and primary goals stated in the medical malpractice action: arbitration and caps on non-economic damages. It does both of those things. As the Florida legislature has said, it is the policy of the state of Florida to do. That contract should be upheld not only because it's consistent with the state policy in Florida, but because also the Federal Arbitration Act said arbitration clauses, private clauses for arbitration between two parties, need to be enforced and upheld, even if there is a state statute that suggests otherwise, or even if a court determines that it is the public policy otherwise.
Does it determine those if the cap? I can understand when you say an arbitration proceeding, but you've got other provisions, caps and limitations, and it's not just arbitration, it's additional things that happen. Does that law apply under those circumstances as well as the limitations?
Not directly, though the AT&T Mobility versus Concepcion case said if there's a disproportionate impact on arbitration clauses, then the court can also look at that. In other words, if you have a situation where, the arbitration clauses keep getting struck down because they're attached to some other thing, then you may have federal arbitration provisions. Thank you.
Let me start by answering the questions I was asked by two of you. In Section 3B of our brief, pages 29 through 42, we address the public policy issues surrounding the Moranis decision, but at the end of that section, I address in detail the deceptive conduct that took place here, and I conclude the section by saying the disclosure failures were never considered by the court below because an evidentiary hearing was refused. Those disclosure failures should allow Franks to void this contract. Furthermore, if an evidentiary hearing were held under the sliding scale analysis, this agreement should be void or would be void for unconscionability as well as fraud in the inducement, and address Romano and Prendergast. Then at the conclusion at pages 46 and 47, we specifically raised those issues again and asked that it be remanded. And I do appreciate Mr. Mathis acknowledging we did raise those issues at both levels below. I think there are some very important points that were just raised that need to be addressed. First of all, if we're going to honor the findings of Acharte and St. Mary's finding that this scheme was constitutional, both of those cases hold that it is a comprehensive scheme and that all aspects of this have to work together or the entire scheme fails. Both of those cases say that. And the St. Mary's case specifically speaks to the arbitration sections where we lost all our rights in this agreement, and it says that that section is not voluntary, and that statement is at page 972 of the St. Mary's case. Moreover, it is erroneous to claim that this defect can be overcome by the fact that arbitration is voluntary. Arbitration is not voluntary according to section 766.207, and it goes on to explain why.
How is that affected at all by the new Supreme Court case that your opponent just alluded to?
Well, let me say this. If, in fact, the Federal Arbitration Act preempts sections of what was done by the legislature relating to this, then the constitutional underpinnings are gone, and this entire act is unconstitutional. There are certainly arguments that Marmette would not necessarily do that. If you read Marmette, unlike many federal decisions, it's actually a pretty short decision. And what it says is the West Virginia court entered an order that said we are not going to allow any pre-arbitration agreements as it relates to nursing home cases. And the U.S. Supreme Court says the Federal Arbitration Act says you can't do that. We're remanding to you to determine whether this arbitration agreement is void for other reasons relating to public policy, but you cannot rule that there can never be arbitration in this area. The issue that we've presented to this court is not the issue of whether or not medical malpractice cases can be arbitrated. The issue is, can they eviscerate our rights under this comprehensive medical malpractice scheme? The comprehensive medical malpractice scheme was not passed to benefit individual doctors. If that's why the legislature did it, there'd be equal protection problems. It wasn't passed to hurt plaintiffs. It was passed to reduce health care costs to benefit the public. And when you allow individual physicians to say, we don't want to play, we're not going to follow these rules, then they don't have the incentives to do the things that the state legislature said they have to do to reduce costs. The purpose of this set of statutes was prompt resolution, not let's send it to another forum. The purpose was prompt resolution. And so they set a series of tiered caps and sanctions that were supposed to integrate together to encourage people to either resolve the case or to go to arbitration and only litigate damages, which significantly reduces the cost to the system. They sidestepped all of those processes, and they did it for their own benefit. And in doing so, they eviscerated the rights of the plaintiff under this comprehensive statutory scheme. The statutory scheme...
If you could sum up pretty soon.
Yes, sir. The statutory scheme is there with a quid pro quo. And Charte and St. Mary's make clear that there are benefits that are given to the plaintiff that are not common law benefits, or there'd be no constitutional basis for it, and they took that away from us. Thank you.
Thank you for your arguments. The court will take a 10-minute recess.
Please rise. Court will reconvene in 10 minutes.
this morning is Young versus State of Florida. You may proceed.
Thank you, Your Honor. May it please the Court, my name is Jim Wolchak, Assistant Public Defender from Daytona Beach, and we represent the petitioner in this discretionary review case wherein the 5th DCA affirmed his conviction for burglary of a dwelling and certified conflict with Munoz versus State, and held that a house that's been completely gutted for renovation maintained its character as a dwelling for the purpose of the burglary statute. As the state notes, the legislature elevated the status of a home as an owner's castle, revising the common law definition of burglary of a dwelling by enacting 810.011, which, unlike the common law, does not depend on actual occupancy, as this court held in Perkins versus State. Under that definition, a building which has a roof over it and is designed to be occupied by people lodging therein at night is a dwelling. This court noted in Perkins that under the statutory definition, the design of the building is paramount.
So why doesn't this building structure, in this case, fit the very definitions that you're talking about?
Well, we submit that, as the court noted in Perkins, the character of a building may be changed. Certainly, the legislature did not intend to give greater protection or greater punishment to people who break into a building that used to be a house when it was built in the late 1800s, but has now been converted to a doctor's office or to an attorney's office.
Why don't we just talk about this case? This is not a situation where it was a house that's now being renovated to do something else. This is a house that was being renovated, and the renovations were substantially complete. So why isn't this a dwelling?
We submit that once the home is gutted, it no longer has that design anymore. It's a blank slate that can be written on and changed. And
was this house gutted, or was this house substantially finished?
This house, the testimony by the contractor that was working there indicated that the house had been gutted for renovations, and by the definition of gutted, that's tearing out the entire interior. We submit then that because it had been gutted, it no longer at that time was designed for these protections.
But doesn't the testimony indicate that they had done a renovation, but it was about finished? So it's not in a state. I mean, it's like any dwelling at some point would have not been completed. But the facts here seem to be a little different. When you talk about it having been gutted, you sound like it is currently in a state of being gutted. And I don't think that's really fits the facts here, does it?
No, the facts were that it was in the process. It was almost completed with this drywall having been hung.
They were basically in there taking the drywall,
Correct.
the leftover drywall. They were cutting up what was left in there and taking it out.
Correct, Your Honor. But we would submit that you have to have a bright line. You can't say, okay, it's been gutted. It now loses its character as a dwelling, but then it gains it back when they're almost completed. There's been no certificate of occupancy. We submit that would be the point when it becomes a dwelling again.
But you could, I mean, for a CO, you could have just minor zoning problems or building code
that's correct.
issues. I mean, it could be absolutely livable.
That's correct.
But you need you have to have a washer here or a plug here. I mean, it's
correct, Your Honor. But we submit once it has been gutted, that's when it loses its status as a dwelling, its character as a dwelling, and it doesn't regain that. We submit until it is
a CO.
A CO, right? Thank you.
And where do you and what case law do you base that on?
We base it on the language in Perkins,
which says designed or suitable for habitation.
Right, but it also
what is the
recognized
controlling factor.
That it's where its character is substantially changed or modified to the extent it becomes unsuitable for dwelling. We submit that happened here when it was gutted, Your Honor.
Why isn't it? Why can't it just be a question of fact for the jury to decide whether it is a dwelling or not, like any other element of the crime?
We submit that the evidence here that was given was insufficient to make it a jury question, Your Honor. Where it had been gutted, we submit that under Munoz and the language in Perkins, which relied on which Munoz relied upon.
As a threshold matter, was this even preserved for appeal?
No, Your Honor, it was not. We admit that the trial attorney was focused more on the defendant's theory there that this was a drug transaction, that he got this truck through payment for drugs.
And so
no, but we submit that it is fundamental, and this court in FB versus State recognized that there still are exceptions to the general rule that a motion for judgment of acquittal must be specific.
And what's the exception that's applicable here?
That it's fundamental error, that the evidence that was presented affirmatively shows that this element was missing, that the crime charge was not
And the
committed.
element that was missing is that this substantially completed house was not a dwelling. Is that what you're saying?
Yes, because it had been gutted at one point and was not completed yet by a certificate of occupancy. FB recognized this exception and talked about the general rule being in policy that the state should be allowed to reopen its case to prove any technical issues that weren't there. But where the evidence affirmatively shows that the crime charge was not committed, then it is fundamental error that the appellate courts can review. And this court cited those cases approvingly in FB versus State.
I guess my problem with it is that if it is sort of a sliding scale issue where you've got, again, from a shell up to the actual dwelling, then I'm not sure I understand why it's not, as Justice Varga was saying, more of an evidentiary issue as opposed to a fundamental error issue that has to be raised. So could you explain that? I'm not seeing the distinction. I mean, again, here, if it was the beginning phases, you'd say, well, there's no way that you could ever determine it's a dwelling, but this was almost the end of it. And so what's your argument on that?
The argument is notice to people, to defendants, that they are breaking into a dwelling.
So wait, let's see. Okay, so in this situation, this defendant wanted to rob somebody to take a car?
That's what the state alleged,
okay,
yes.
so he knows, let's assume that he's charged with knowledge of the law. So the difference between a dwelling and an unoccupied structure is, what is the difference in the penalty?
Correct.
What is the difference?
It's it goes up a degree.
A degree.
I believe, yes.
Does he rob the person that's there?
The testimony that he was found guilty of was, yes, he robbed the person. He came in and said, "Where's it at?"
Okay, so the robbery is not affected by whether it's a dwelling.
No.
Okay. So I would imagine, if we look at
dwelling.
penalties, that robbing this person at gunpoint is going to be the major charge.
Yes.
Right, so this is sort of subsumed, isn't it? I mean, I'm not saying it's not a big deal, but just trying to understand where we are in this. Okay, so he comes in. Does he know at the outset, well, I'm going to pick a place that's, first of all, he knows it's occupied because he knows the guy's there, so the occupied is really the bad part. But I'm going to pick a place to look from the outside that it was just an abandoned structure. I'm trying to understand when you say notice. Like I said, if he knew this wasn't a dwelling, he knew it was just a place under renovation.
Yeah, his testimony was he knew the victim and knew the victim was working there and had exchanged drugs for the truck in the past.
So the guy could have been, you call a repair person into your house, and they're working in your house fixing the garage door, and I'm just not seeing the legislature, which we're dealing with as far as what they meant to do by increasing penalties for a dwelling versus an unoccupied structure. Why the nicety of whether that it was just about completed is not essentially that it was a dwelling, at least for a jury question as opposed to a matter of law.
We submit that the definition provided by the statute talks about the character of it, and Once.
Well, didn't it look at from the outside that it looked like a regular house?
There was no testimony as to that, Your Honor.
Well, we would assume so if all that was left was a little bit of drywall. I mean, there's no evidence that there was no roof on it. There was no evidence that that didn't look from the outside like a house. No one ever put on that kind of evidence, did they?
No, Your Honor.
I mean, that's why the preservation issue seems important, because if the prosecution was alerted that this was an issue, they could have put additional testimony on just to fill in that blank. I mean, that's to me why the preservation is a big deal.
Again, we submit that it lost its character once it was gutted and doesn't regain that.
So when?
And the certificate of occupancy says that it's now a dwelling and suitable for dwelling.
Did you say that in your brief about the certificate of occupancy?
No, Your Honor.
That just pops up today.
Well, we're talking about the character of it and when it loses it, and the question was when it regains it.
There are people that they'll say when you try to legislate from the bench, it just strikes me that if we were to actually say, well, until a certificate of occupancy is granted, that it's not a dwelling, we'd be supplying something in a statute that actually has no real public policy purpose or any consistency with the legislative goal on making a residency, a dwelling, have greater penalties than an unoccupied structure.
Well, again, as pointed out by the state, the legislative policy was to provide greater protections, greater punishments for one's castle, and this was not one's castle. It wasn't owned by the person that was going to be living there. Contractor bought it and gutted it for renovation purposes.
Or use as a dwelling.
Pardon?
And he gutted it and was redoing it for use as a dwelling.
Yes, Your Honor.
Okay. I think you have a more interesting argument actually on your carjacking case. Do you plan to argue that at all?
Yes, Your Honor. In point 2 that we raised in the DCA that they did not address, we submitted that the defendant went into the house at the state's testimony was at gunpoint and said, "Where's it at?" The taking, he took the gentleman's cell phone, his wallet, and his car keys or truck keys, and we submit that.
What more do you submit that the defendant had to do to make this a carjacking? He forcibly, with a gun, took the keys from the possession of the owner, went outside, started the vehicle up, and left. Right. What more would he had to have done to make this a carjacking?
We submit that
What's
under the Flores case from the 3rd DCA, that the taking of the truck was not by force. It was separate from the robbery inside the house.
It's clear he took the keys by force.
Yes, and as in Flores, the keys were also taken by force, and the court ruled it was not a carjacking.
The 4th DCA in Carter versus State, I think they looked at it from a similar issue, that we should look at the continuous series of acts or events. Isn't that what we should be doing? What you're telling us is that the threat to take the car was not contemporaneous with the actual taking of the car.
Yes.
Therefore, it's not a carjacking.
Yes, there was no violence in taking the truck outside.
But the
just
events,
like in Flores.
The events that led to the taking of the car occurred earlier, and like the 4th says in Carter, we got to look at the big picture, the whole event. Why can't we do that here?
Right. The 3rd DCA also said that in Flores, but said that this was an afterthought. This gentleman went in there. Where's it at? Obviously, not talking about the truck that was right outside in the driveway that he walked past when he came into the building. So we submit that under Flores, which is similar, that was the robbery of a lady in a beauty shop where they took her keys from her purse by force, and the court ruled that was not a forcible taking of the truck for carjacking.
So how do you distinguish this, however, from Baptista John?
Just because it appeared to be an afterthought where he said, "Where's it at?" He was obviously looking for something other than that, and we submit that then the the force.
But in that case, didn't he take the keys from the man's pocket? They had beat him up, and they took his keys, and they went out to the car. How is this?
And it appeared
really?
that was his intent when he robbed the person. Here, there's no showing that was his intent when he robbed the person.
Well, did he drive off in the truck?
Yes, he did.
How can that be an afterthought?
We submit that that's all that the evidence shows, and that this was a robbery of the keys and the wallet and the money inside the house, but just a grand theft.
Was there money?
Truck.
I don't recall that there was any evidence that there was money inside the house that was taken.
I'm sorry, of the victim that he had in his wallet.
Was there even money in the wallet? I thought there was checks and stuff like
Credit
that.
cards, I think there was money.
And that was not taken or was taken?
It was taken. They later recovered all that inside the truck when it was recovered a few days later. We submit this court, we ask this court to reverse and strike those convictions and impose lesser included offense. Thank you.
May it please the court, my name is Chris Davenport and I represent the state of Florida. To address this dwelling issue, as this court's hypotheticals show, once you get into this Munoz theory of it has to be suitable for somebody to live there, you're getting into all sorts of things where, you know, at what point does the gutting make it so that you can't live there, and then all of a sudden you need a certificate of occupancy? That clearly was not the intent of this court's language in Perkins. Instead, as the dissenting opinion in Munoz pointed out, the whole focus of the dwelling definition is the design of the house.
Well, let me ask you this. Let's assume hypothetically that I live in a residential neighborhood. Everybody lives in houses and 4 bedrooms, 2 dogs, 2 kids, the whole 9 yards. And I decide, in complete violation of zoning laws, I'm going to disregard all the zoning laws. I'm going to gut my house. I'm going to turn it into an insurance agency. And if that's my intent, while it's gutted, would such an intent, with such a design, would that take my house away from the definition of dwelling?
Yes, once you change the design so that it's not designed to be used for lodging by people at night, as the statute defines it, then it's not a dwelling anymore. Then it becomes a business, which is a burglary of a structure.
I guess if a home is gutted, there's nothing there, no walls or anything that would indicate that I'm going in that direction as far as the design is concerned. We would have to be, I would think, and I guess it's a friendly question, it would have to be a factual determination by the trier of fact as to whether that is the intent and the design or whatever.
The trier of fact would have to see if it met the statutory definition of, is this a building that's designed for use as lodging by a person at night? And if the owner of that building comes in and says, yeah, I took everything out and I was just about to bring in my office furniture or put up partitions to make my offices, then under those situations, I would grant a judgment of acquittal on the dwelling issue, and it would be a burglary of a structure, where if that's the only testimony that's presented. Because, again, you're focusing on the design of the building. Is it designed, as the legislature requires, to be lodging for people at night? The problem is when Munoz comes in, they said it's not about the design, it's about the habitability and would somebody live there, and that's when you get into these amorphous concepts of certificate of occupancy and what about the electricity, and you don't need all the 21st century amenities for it to be a dwelling. If you have a fire in your vacation home and you're having it fixed up, I wouldn't want to live in a place like that. But it's still a dwelling. It still maintains its characteristics as a dwelling. And under the legislative definition, it remains a dwelling. It doesn't change into something else and go back to a dwelling once it seems like it's good enough that I would stay there. That's not what the test is. The test is about the design.
So even if a house is in fact gutted, but it still has all the outside trimmings of being a house,
if it's gutted
it's still a house.
It's still a house, and unless the only evidence is that the design is being changed. The only situation where it stops being a house is where all the evidence says we're in the process of turning it into an office. that's when it stops meeting the definition of dwelling as the legislature has set out, not as the court in Munoz. Once these lower courts started following that Munoz decision, that's when you get into, well, was there electricity and was the water on? And the next logical step is, do you have a certificate of occupancy? And that's not what dwelling is in the statute.
But
so we've gone off on this
really
tangent.
An interesting argument. I mean, it's strange because then the criminal law depends upon the subjective intent of whoever owns it, because there are many law offices, for example, that operate out of a house.
Right.
And they don't change anything. It has same bathrooms and showers and kitchens, and they use bedrooms for offices and living rooms for waiting rooms. So it really then becomes the subjective intent of whoever owns it.
Well, it becomes the design of the dwelling.
Well, again, I'm saying you have the same design. It's just a question of how you want to implement it. It's that there's no difference at all in an office that you take out that furniture that's residential in nature and just put a desk in the bedroom. That's what I'm saying, is that
right.
It just seems unusual. I'm not aware of any other area of the law where the criminal statute depends upon really the subjective intent of an owner, and it can vary from without any way to prove it, except I say, I practiced out of an office that was a home before. Mm-hmm. So, I mean, it's that kind of thing is what I'm suggesting. So I don't know what the answer is. I'm just
right.
Very
that's
interesting.
Just kind of the nature of you looking at the design of the building. Was it designed for somebody to be lodging
So if someone could live in it as a dwelling.
Right. If it's designed that way.
But let me ask you that question about, first of all, what are the difference in the penalties between burglary of a dwelling and
burglary of a structure? One's a second-degree felony and one's a third-degrry felony.
And what's the difference?
So that's 10 years difference.
And here he had a robbery of an armed robbery. What was the sentence?
He got 20 years on each count, all to run concurrently. Because there were, in this case, he did an assault or battery inside with the burglary, so that upped it to the first degree
not
felony.
that this doesn't really affect his sentence because it's concurrent?
Right.
On this, though, and it is, if the purpose of the legislature was to make sure that Floridians that occupied homes see greater protection than those that didn't occupy homes, the fact that this was not yet, it wasn't like I was renovating my house and I was living there or I had moved out. This was a place that nobody was living in. Is that correct?
At the time, it had been bought by a contractor, and it sounded like we were going to fix it up.
I mean, was there furniture in there?
There's no evidence about that. They were redoing the drywall. That's what we know.
So if there was a development and there were 10 houses that had been built, but nobody was in them, nobody had intent, and somebody goes ahead and burglarizes those places, those are all dwellings, even though nobody has lived there or intends to live there in any of the near future?
Yes, because under the statutory definition, the design of the structure is such that it's intended to be
okay, and we don't, in this situation, was there evidence that the whole front, everything, again, I'm assuming there was a roof on there and
right.
that it looked like a house?
Right. I mean, nobody testified there's a roof on there, but he's doing drywall. I can't imagine they would do drywall without a roof. So we can
wouldn't stay too dry, would it?
Right.
Yes.
You have it. You didn't meet some of the contractors during Andrews.
That's right.
After Andrews.
So, again, this wasn't raised in the trial court, so we don't have a huge amount of evidence on this.
But there is a conflict, right, of decisions, or is
there's a conflict? There's a certified conflict.
I mean, there's a brilliant dissent by Justice Kennedy on this issue.
Yes, there's a brilliant dissent that would bring these courts right back into line and eliminate all of this amorphous concepts of who would stay there and how much electricity was there and all of these things that are not there under the statute. So the state would ask that you adopt the brilliant dissent in Munoz as the law of the state and eliminate all of these issues. As far as the carjacking goes, in the course of the taking, as long as it's a continuous series of events, this guy came in, took the guy's car keys, and seconds later left in his truck. He left the wallet on the back seat. He left the guy's tools. The truck was the whole object of this. Just he didn't need to wait for the guy to come outside and be next to his truck to commit a carjacking. It's in the course of the taking, and this is clearly in the course of the taking.
How about the third district case that?
That opinion is clearly distinguishable, so I would say no. Well, in that case, they came in and took the lady's purse and then locked her in a back room. And then it seemed to be, according to the court's version of the facts there, it seemed to be more of an afterthought that he was walking away with this purse and went, oh, there's car keys, and went to find them. So in that situation, it is distinguishable here because it wouldn't be in the course of the taking, would be the argument. You know, I think it's certainly better facts for the defense in that case. I would think that would be more of a jury question. So, if the court is inclined to disapprove of Flores, that would be terrific. And in all other three respects, we'd ask the convictions be affirmed. Thank you.
You have some rebuttal time if you.
I have nothing further unless the court has more questions.
All right. Thank you for your arguments. The court is adjourned.
Please rise.
Jesus, a Kennedy love fest.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.